Hi, I'm attorney Ben Schwartz. Today we're going to take a question from a viewer from Carol in Maryland. She says, I was recently serving on a jury and I was picked to be on a personal injury case. And it was a little bit difficult to figure out how much to award the plaintiff because we never heard what she was going to do with the money. And essentially, Carol says, don't you think the jury should find out where the money's going to go and what the plaintiff's going to use it for? And the answer is, I don't know. I never really thought about it before, to be completely honest with you. There are as many cases as there's different reasons why. There's different reasons why people bring cases. A lot of times people bring cases because they're getting jerked around by the insurance companies after an auto accident and they go to a lawyer to find out about their legal rights. There's not always a master plan for what the plaintiff is going to do with the money that the jury awards. I've had cases where the plaintiffs will use the money that the jury awards to set it aside to use it for health care costs in the future. I've had cases where they've set it aside to use it for education costs to put their kid through college. I've had situations where people have used the money that they've gotten from personal injury settlements to buy a new car, to buy a new house. I've had situations where the people were so far in debt by the time they got their settlement that they just used their settlement money to pay off debts. I've had cases, where the money goes for all sorts of different things. And I think that the reason we don't explain to the jury what the plaintiff is going to do with the money is because it's not really relevant admissible evidence. It's not really relevant to the issues under consideration in a personal injury trial. So for example, if you're a juror in a personal injury trial, the judge wants you to make a decision as to liability. Was the defendant negligent? Did the negligence cause injuries? Nature and extent of injuries, and what is fair compensation for the person who sustained those injuries. What they're going to do with the money isn't really relevant to the nature and extent of the injuries or what fair compensation would be for that loss. So that's, I think, why we don't tell jurors that information. I do want to say that I thought this was a very insightful question. I thought it was a very good question. And it raised some, it sort of got me thinking and raised some topics in my mind about things we don't tell jurors. And you've got to realize, from my perspective, I've been practicing law. I've been litigating cases for, almost 20 years at this point. I got admitted in 2001 to practice law in Delaware. And from my perspective, I think that there were things when I was a new attorney that I found surprising about how things work. But now it's sort of been so long and it's so ingrained that it seems normal to me. But I kind of took a couple minutes to think back through things that I used to find sort of surprising when I was a new attorney. Some things that we don't tell jurors that I used to feel was kind of strange, sort of still feels kind of strange, is we don't tell jurors about prior bad acts or prior crimes. So if I'm suing someone, let's say I'm suing a drunk driver who ran a stop sign and smashed into my client. That drunk driver was on his 5th DUI. I may not be able to tell the jury about the 4 prior DUIs. The reason is because in a case for compensation, in a personal injury case where we're seeking compensation, those prior drunk driving convictions aren't really relevant, and they may so cloud the minds of the jurors to make them no longer objective. And the judge doesn't want to have the jury make decisions from a place where they are prejudiced against that defendant because he's got an illness or a drinking problem. Another thing is subsequent remedial measures. Let's say that you slip and fall on someone's property due to a defect in the property. It's a great big pothole. As soon as they find out that you fell, they go out and they fill the pothole. The fact that they filled the pothole is not likely to be admissible evidence at trial in the personal injury case against them. And the reason for that is because we have a rule that says subsequent remedial measures aren't admissible to prove negligence. We don't want to stop them from filling in the pothole because they feel like it might be used against them at trial. Insurance coverage. One of the things that people tell me they find very surprising is when they're on a jury in they serve as a juror in a personal injury or wrongful death case, they never hear about how much insurance coverage the defendant has, or even whether the defendant has insurance coverage in the first place. And it's something that we just don't tell jurors about. So there's sort of a laundry list. I could go on. There's sort of a laundry list of things we don't tell jurors. Some of it seems very strange. Some of it seems very common sense to me. I'd like to know what you think. Let me know. Send me an email or give a comment on this video. Let me know what you think. And I'm attorney Ben Schwartz. My email address is mail, M-A-I-L, @benschwartz.com. This has been another episode of 10 with Ben. Thanks for watching.